Assalamualaikum warahmatullahi taala wabarakatuh. Hello, darling. Good morning. It's me again. So we are in your week 10 of lecture. The topic is Interpleader proceedings. So, what is Interpleader proceedings? So before I proceed, last lecture I covered on third-party proceedings. Can you still recall what is it? So basically it's an application to join a third party in the suit. Now we are moving on to interpleader proceedings. What is interpleader proceedings? Okay, so this is what you are going to learn. Okay, this is uh, covered. These are the learning outcomes covered under your interpleader proceedings. So entitlement to relief by way of interpleader and claims to goods taken in execution, the mode of application, service of summons and notice of application, powers of court hearing this origin summons and notice of application, power to order sale of goods, okay, power to stay proceeding, withdrawal or admission, other powers, one order in several courts or matters, and then discovery and trial of interpleader issues. Okay, these are what you're going to cover in your interpleader proceedings. Okay, so basically that's wrong. There is no order 1 is order 17. Okay, have a look at your order 17 for interpleader proceedings. Okay, rules of court again 2012. Have a copy of it or you can download it on the internet, or actually I've downloaded it for you in your rules of court. In your goals if it's there. Okay, I hope it's there. All right, so basically order 17 is on interpleader proceedings. Okay, it covers from rule 1 okay up to rule 11. All right, so now there are two types of interpleader proceeding. One is the stakeholder interpleader and another one is sheriff interpleader. Okay, so a stakeholder interpleader is basically when two or more persons make a claim to a sum of money of a goods or chattel held by a person, and is this person unsure of who is the rightful owner. So basically he may then apply to the court under order 17. Okay, one of the rules of court for relief by way of interpleader. Okay, so basically these are the situations where these people can be interpleader. Okay, interpleader is a suit pleader between two parties to determine a matter of claim or right to property held by a third party. You can look at this YouTube when you are free. Okay, so interpleader proceeding is a person sued in respect of to a property. He personally disclaims any interest in it and requests the court that rival claimants litigates their titles between themselves and relieve him from responsibility. All right, and then the interpleader relief is discretionary. It cannot be claimed as of right. All right, so the situation of interpleader that I mentioned just now is a third person uh, makes a claim to the sheriff to the goods. So he, after he has seized pursuant to execution, okay, so the sheriff will issue an interpleader application. He will be a sheriff interpleader, so he will determine the rights. He wants the court to determine the rights between the various claimants. That is under order 17 rule 1. Another type of interpleader is when a person, a stakeholder, like the one that I mentioned first, okay, who is under legal liability to pay a debt or money or goods or chattels to a particular person, to a particular person, some third party to make a claim. Okay, then the stakeholder may take out an interpleader proceeding to determine the rights between the various claimants. Okay, these are the situations of interpleader proceeding. This seems an area of exam that is no, yeah, no. I'll think about it later. Okay, procedure. So basically, these are among things that is important. Okay, when you apply for interpleader proceedings. Okay, um, the interpleader has no personal claim to the property. He's seeking the guidance of the court to determine the rights of the parties. Okay, he must give his notice of claim in Form 24 to the sheriff charged with the execution process, including his notice his statement of address for service. This is under Order 17, Rule 2, Sub Rule 1. Okay, and then on receipt, the sheriff must forward the notice of inform 25 to the execution creditor, that is under Order 17, Rule 2, Sub Rule 2. And then the execution creditor must within 4 days, after receiving the notice, give notice informing in Form 26 whether he admits or disputes the claim. This is stated under Order 17, Rule 2, Sub Rule 2. If the execution creditor disputes the claim and does not respond within the time limited, the sheriff may apply to the court in Form 27 relief, Order 17, Rule 3. Okay, for the claimant to succeed, he must satisfy the court that his claim is bona fide, in good faith, and is not instituted to defeat the execution proceeding of the judgment creditor. Okay, the application by relief or by stakeholder must be made by originating summons. Okay, this is the mode of application, unless in a pending action must be made by notice of application. Okay, remember the early parts when we talk about the modes of originating process. Okay, when we want to determine issues of law, okay, we should be using originating summons. Okay, this is the mode. The format must be in Form 28. Okay, or according to Order 17, Rule 3, and the application must be supported by evidence to the effect that the applicant claims no interest in the subject matter, a dispute other than charges and costs, do not collude with others on the subject matter. Okay, so this is under Order 17. Okay, and then is willing to pay or transfer that subject matter into court to dispose of it as a matter that the court may direct. This is under Order 17, Rule 3. Okay, when the applicant is the sheriff, he does not need to provide such evidence. Okay, that is for the other types of interpleader. Okay, the type. So basically, unless the court otherwise orders, the orienting summons or the notice of application must be served personally at least 7 days before the written day, or this is stated under Order 17, Rule 4. On the hearing application or claimants appear, the court may order, and then that is stated under Order 17, Rule 3. These are the orders that can be ordered by the court. The claimant can be made a defendant in any action. Okay, an issue between the claimants be stated and tried, directing which claimant is to be plaintiff and which is to be defendant. That is to be determined by the court. If the applicant or the sheriff or all the claimants consent, or any claimant so request, the question at issue between the claimant, the question and law and facts are not in dispute, the court may summarily determine the question at issue between the claimants and make an order on such term as may be just. Okay, the claimant who is duly served with the interpleader application does not appear during the hearing, but or appear but fails to comply with an order, the court may make an order declaring the claimant and all persons claim under him forever barred from prosecuting his claim under the against the applicant. Okay, this is under Order 17, Rule 5, Sub Rule 3. Right, and these are the important cases. Poraviapan Aruna Salam Pillai sebagai pentadbir harta pusaka Nadaraja Satimbaran Pillai and Periasami Setambaran Pillai. So in this case, it was stated that the precondition for the state of being sued, of the expectation to be sued in respect of those goods by two or more persons making adverse claim, the applicant must fulfill to give the court to the jurisdiction to exercise discretion to grant the relief provided under Order 17. These are the requirements for interpleader proceedings. There must be some real foundation. In this case, Sri Ralan, he was not actually seeking for interpleader relief, but not really as a person who was vexed by suits from two or more persons making adverse claim. But what he wanted the court to do was to investigate and adjudicate whether the sale was merely a money lending transaction, and it cannot be a ground for interpleader. Okay, in order for an application to succeed for interpleader proceedings, so you must expect that there will be some claims over the property that you are having, so the court that can give make investigation and make the necessary redirections. The second case is the federal court case of the Kim, the Salina and Co and Tan Kiao and another. So basically, under this case, although interpleader under Order 17 using originating summons as a special provision under Order 17, type of, however, is a type of originating summons accepted under Order 28, Rule 1 of the ROC. We look at Order 28 and making sense of what it says. So Order 28 is for originating summons procedure. This is the procedure for originating summon. Okay, so basically when you want to proceed under interpleader proceeding, you use originating summons, and the procedure is stated under Order 28. The interpleader, in this case, the appellant was not making a claim or bringing an action against the defendant. They could not be counterclaim. In this case, when there seems to be countervailing claim, the appellant filed the interpleader summons to seek the court's assistance to get the court to decide whom should it come for the titles. The summons put forward to correspondent to put forward their claims. Okay, so basically, Order 17 make no provision for counterclaim. Okay, so basically I think that's quite understandable or logic, in the sense that what the court is doing is not to take into account of any counterclaim, but to adjudicate of these various claims and to decide, look at the facts and the laws, and to decide which is the rightful party to that property, chattel, or whatever. All right, get what I mean? So I think it's logic in that way why there is no provision for counterclaim. So sheriff interpleader, you can have a look at this sheriff interpleader. That is the situation in England. So basically, can pay well, take it away. So basically, the sheriff in the United Kingdom, they are quite strict in the sense that if you don't pay it on time, they will get whatever order that they can get. They can get whatever property that they are entitled to according to the court order to satisfy the judgment sum. Okay, so that's not really on interpreter, but I want to show you what the sheriff they can do. Okay, let's say afterwards the case is actually settled, the person has actually paid or fulfilled the judgment sum, and he's claiming for that property that has been taken away or seized by the sheriff. So in future, these interpleader proceedings can be applied. All right, you got it. So I guess it's not that difficult, right? Okay, so the interpleader proceeding again, the claimant they has no personal interest in the claim. So remember here, the claimant here we are referring to the other parties. Okay, not the interested party. The person who is in whole of that property. Okay, the what's the name? The stakeholder interpleader, and then the sheriff interpleader. So for the execution of the goods, they will need to ask the court's direction on the good chattels, and the procedure is stated uh, in Order 17 and in Form 24 and up to Form 30, and what the court order is stated under Order 17. Mode of application, service, notice of application, what's the powers of court is stated under Rule 5, and the power to set aside courts of application, power to stay proceedings. Okay, this is among the power, and then withdrawal or admission and other powers. They can be other powers that they think things fit. The court can make one order in several causes or matters. Then the court may order discovery. Okay, and the court can order a trial of interpleader, which is Order 17. So 11. This court's power is important for you to know. You can read it. So basically, like I mentioned to you before, at times, not to say that the court are clueless. Maybe the court is asking you, okay, when you ask for an application, they will ask you, what is your ground? Okay, so they will ask you, basically, they will ask you, what is your ground for application? And then when you say, okay, I would like the court to adjudicate or to give an order, okay, as to my interpleader application, and then the court will ask you, do you think what are the powers that the court can order? So it's good that you are well versed. No, it's good. It's a matter of practice that lawyers should be well versed of what the court can do or cannot do. That is to support your argument for application. All right, that's all for today. Enjoy. Have a nice day. Assalamualaikum warahmatullahi taala wabarakatuh. Bye. Happy COVID PKPP.